I will note the appearance of Mr. Sullivan on behalf of the plaintiff, Ms. Bailey Hobbs on behalf of defendant. This matter is before the court on the plaintiff's motion for modification of judgment of divorce pertaining to parenting time to enforce the judgment for makeup parenting time and other relief. Mr. Sullivan.
So as the court will recall, we were here last week and the court adjourned the matter to afford defendant an opportunity to have counsel file an appearance and a response, which has now occurred. As noted last week, we're simply seeking a specified schedule pursuant to statute that is consistent with the party's practice since roughly 2018. My client has not had parenting time with the party's daughter since March. The parenting time should resume. The court, in fact, said to the defendant last week that the court's order is in full force and effect. And that means in this case that the plaintiff is entitled to a 48-hour continuous period of parenting time each week. And the parties have developed a schedule as noted in the motion to affect the court's order. It's interesting in paragraph 14 of the response, the defendant makes a point that if the court requires parenting time to resume, there's two things about that statement. Number one, it is an acknowledgement that parenting time has ceased, and that's in violation of the court order. And second, it's an acknowledgement that in the defendant's mind, it's okay that it has ceased in violation of the court order. The other interesting thing is the defendant's response to the attachments to our motion. Those attachments reflect the goodness of the relationship between my client and his daughter that existed up until March, when there was difficulty between my client and the defendant, which led to the defendant's decision to allow the minor child not to go to plaintiff's residence for his parenting time. So one other point, Judge, with regard to the subject of counseling, my client does not object to counseling, provided the counselor is selected by my client, which is appropriate given the claimed need that the counseling must be between my client and his daughter. That he select the counselor, he doesn't have any objection to that. Daughter, with the counselor selected by father, resumes and continues pursuant to court order.
Okay, thank you. Ms. Bailey Hobbs, your response.
Your Honor. While defendant agrees the parenting time order needs to be changed, however, she believes this court should enter an order reflecting the parenting time that plaintiff has been exercising, not the loose schedule that the parties agreed to follow 4.5 years ago. Despite what plaintiff has alleged, defendant supports plaintiff's role as the child's father. While defendant father has not had parenting time with a minor child recently, that's because of the breakdown of his relationship with the child, not because of the child's mother. My client has tried to facilitate a meeting between the child and her father so that they can work out some issues, but plaintiff will not agree to the meeting with what the minor child wants to do. The fact of the matter is that this child is almost 13 years old. She's entering her teen years. She's been struggling with her relationship with plaintiff father for some time. That makes...
Hold on. Apparently we just lost Mr. Sullivan. Go ahead, Ms. Bailey Hobbs.
Thank you, Your Honor. As I was saying, is the fact of the matter is that this child is almost 13 years old. She's entering her teen years and she's been struggling with her relationship with her father for some time. That makes what looks like a simple parenting time issue much more complicated. My client has done everything short of pushing the child out of the door to encourage the parenting time. In fact, my client believes that if she were to physically force the child into her dad's car or house, that would further escalate the situation, as then the child would then have a strained relationship with both parents instead of just one. There are contested issues of fact regarding all the issues raised in plaintiff's motion. We're asking the court to schedule this case for an evidentiary hearing. While we wait for that hearing date, defendant is requesting the court appoint a guardian ad litem, which she is prepared to fully pay for if necessary. Defendant believes it is important for the minor child's interest to be represented in this case to prevent those further issues down the road. Regarding the therapeutic reunification counseling, my client would ask that the parties agree on the counselor. Defendant is hopeful that with the assistance of the guardian ad litem and the therapeutic counseling, that the minor child and plaintiff can repair their relationship, which will significantly help with the parenting time issues. Without further exploration of these issues and efforts to repair that strained relationship, it's merely setting the parties up for failure, which will then lead to additional motions regarding parenting time and contempt being filed, and thus more time in court. As I stated, defendant's asking the court to appoint a guardian ad litem to this case. She believes that Kimberly Wickham would be a good fit for this case. She also asks this court to order the parties, plaintiff father and the child, to participate in the therapeutic reunification counseling with an agreed upon therapist and schedule this motion for a hearing. Nothing further, Your Honor.
Okay, thank you. Mr. Sullivan, are you opposed to a GAL being appointed?
No, there's no opposition to that.
Okay. It's been recommended by the defendant that Ms. Wickham be appointed. You have a problem with Ms. Wickham?
I need to talk to my client about that request. Perhaps we could discuss and come up with a guardian ad litem that the parties agree upon.
Okay. Well, we'll give you a period of time to do that. The court would appoint a guardian ad litem. The defendant stated that she would pay the cost of that, so she'll be responsible for that. And if you can't come in to an agreement as to the GAL, then the court would again appoint someone at that time. I would state in this matter, the child has been in counseling with Leslie Dingy, but again, that was pursuant to the apparently the defendant's unilateral actions. The court will in fact terminate that counseling and order that the child would and the parties would see a counselor that they can mutually agree upon. If they can't, then bring the matter as to who the counselor and everybody's recommendations back to the court, and the court will again address that as well. Court will just state that the parties have to comply with the orders of this court. In this particular matter, the court will reserve on, again, on the makeup parenting time, reserve on the attorney fees, again, pending an evidentiary hearing, which the court will conduct as soon as, again, the parties and the minor child have had sufficient time to go through counseling, probably delay that about 90 days. And at the conclusion of that, we'd have the counselor make a report to the court and to the parties, and then we will schedule it for a hearing at that particular time. Anything else, Mr. Sullivan?
No, Your Honor.
Ms. Bailey-Hobbs?
Nothing further, Your Honor.
Okay, thank you. We'll end this matter at 9:15 a.m. Ms. Podolsky on behalf of the defendant. This matter is before the court on the defendant's motion to modify judgment of divorce as it relates to custody, parenting time, and support. Ms. Podolsky.
Thank you, Your Honor. As we stated in our motion, these parties were divorced in 2019. That judgment provides that defendant father has standard parenting time or alternating weekend parenting time with half of the summer. However, since the entry of the judgment, the parties have deviated from that schedule, and the defendant has been exercising significantly more overnights than that each year. And in 2022 alone, exercised 160 overnights. He regularly exercises every Wednesday as an overnight visit rather than a 4-hour midweek visit. And he regularly exercises the Sunday overnight rather than having parenting time end at 6 p.m. on Sunday. This is in addition to multiple other overnights throughout the year. There's also been a change in circumstance regarding the conduct of the parties since the entry of the judgment, specifically the plaintiff. There have been numerous...
He dropped off.
Okay, hold on, Ms. Podolsky. Your client's dropped off. Go ahead. He hasn't rejoined apparently, and obviously for joining, it's the responsibility of the clients to make sure that they have access and that their system is working. So go ahead.
Thank you. As I was stating, the plaintiff has had numerous police contacts since the entry of the judgment. There have also been concerns about lying about the whereabouts of the minor children during her parenting time, leaving them unattended for several hours at a time. The minor children come back to dad's home speaking negatively about their stepmother. We have concerns about school attendance and the academic progress in school. My client attends all conferences and stays in regular contact with the teachers and is trying to address that with them. However, it is difficult because during mom's parenting time is when these issues are occurring. We believe that proper cause, change in circumstance exists to evaluate changing custody as well as parenting time and child support. We are seeking an order of joint physical and legal custody with a week on, week off parenting time. In their answer, the plaintiff does not agree to this, obviously, but has stated that she believes the parties have been exercising 130 to 135 overnights for defendant per year. While we argue that that is more, that is a concession on their part, and we'd be asking for a temporary order in the interim so that the plaintiff mother cannot use this motion as a reason to deviate from a status quo that has been established. So at a minimum, we'd be asking a temporary order to enter of 135 overnights while this is pending and we continue on to an evidentiary hearing.
Okay, thank you.
Thank you.
Ms. Henderson, before you start, you have set forth in your answer that, again, that the defendant does exercise 130 to 135 overnights. One of those being a Wednesday overnight. Is there any problem with having a temporary order which would confirm and affirm that arrangement?
Your Honor, we are confirming that defendant, in fact, has exercised Wednesdays as overnights. Sunday overnights were not regular and very sporadic. As it relates to our response, Your Honor, I don't believe there is a change in circumstances or proper cause for the court to even entertain a temporary order. We have offered plaintiff to make status quo as an order where defendant does have a Wednesday overnight. We could grant him one Sunday out of the two that he has as an overnight, as those have been sporadic. There's no other extra parenting time that defendant has exercised, Your Honor. As it relates to the other allegations with police contact, Your Honor has seen our response. All of those allegations are over a year and a half old or older. So defendant clearly was not so worried about the children that he waited that long to file a motion. There's no allegation regarding school attendance or school progress of the children, Your Honor. That is something that was brought in the oral argument. My client is very involved in the schooling. She has historically signed up the children for schooling. So in my opinion, it's a little bit disingenuous to title this motion as a motion to modify judgment of divorce to imply that there was a typo in the judgment. So we just need to make it this, Your Honor. Even if the client of Ms. Podolsky has exercised 130 to 135 overnights, that's still not a joint custody situation, Your Honor. And every time he does exercise an overnight, he still brings the children to my client to deliver them to school or for the school bus, as his work schedule does not allow him to see them off to school, Your Honor. So we are absolutely opposing that there has been proper cause to revisit the custody as required by Vadvarka, and there needs to be any temporary order, period. We would concede that whatever is status quo become an order, and I think that is the most that Mr. Miller can bargain for at this point, because there's not any showing that week on, week off would be in the best interest of the children. In fact, the children would like to speak to the court if the court decides to move it on to an evidentiary hearing. As it relates to the allegation that the children speak badly about the stepmother, they don't. I mean, that is the woman that broke their family. So it's very, I guess, natural for the children to maybe not like her, but that is not due to anything that my client has done or said. In fact, she refrains from any communication that would disparage Mr. Miller or his new wife. She does not in any way try to alienate the children from the defendant, Your Honor. Further, as it relates to the income that is mentioned in Ms. Podolsky's motion, since the entry of the judgment, we did confirm that my client's income went up a little bit due to the cost of living adjustment. Mr. Miller's income is almost the same for his W-2 that were the parties exchanged prior to the hearing, Your Honor. But Mr. Miller and his wife also started a business that has been fairly successful. And per the Michigan child support formula, section 201C2 and 5, that income from a business in which defendant, even though it's registered technically under his wife, that is a marital business in which defendant works. And my client has people that hired defendant to perform bartending services at their events. So that should absolutely be considered for income purposes. He also works for Crazy Mike's, we believe, under the table, but that is also income that the court will need to include when calculating child support, Your Honor. So I would state that there is no proper cause or change in circumstances to entertain a temporary order while we are waiting for an evidentiary hearing, because evidentiary hearing should not be scheduled. None of the issues that were brought up by Ms. Podolsky rise to the level of fundamentally affecting the welfare of the minor children. And further, we would state that we are okay with status quo. In fact, we offered to put it in an order, but there should not be any consideration of week on, week off schedule for the minor children, because defendant doesn't even get them to school. So it's all on my client, Your Honor. So we're asking respectively that the motion to modify the judgment be denied. And if the court entertains any change, that should only be to parenting time and essentially making status quo part of the order and recalculating child support based on all of the income that is earned by defendant, Your Honor. Thank you.
Okay, thank you. Well, the court has read the pleadings, heard the argument in this matter. It is acknowledged in the answer in this case that the defendant is exercising between 130 and 135 overnights per year. He has done that for a considerable period of time. The court is going to affirm that and order that the defendant would be entitled to 135 overnights per year. The court is not going to summarily decide the matter based upon the pleadings, but the court does believe that there has been proper cause, change in circumstances sufficient to meet the Varka threshold, at least for an evidentiary hearing. I do note the answer in this matter does challenge and dispute some of those items, but as stated, the court's not going to try the matter based upon the pleadings, but will refer the matter to the referee for an eventuary hearing. And you can try to come to an agreement, if you would, as to how you're going to implement the 135 overnights on a temporary basis, and court will simply reserve on everything else pending the referee hearing. Ms. Podolsky, you can prepare that order and talk to Ms. Henderson and see if you can come to an agreement. Ms. Capture, on behalf of the defendant, this matter is before the court on the defendant's motion for immediate appointment of a guardian ad litem and to again cancel or lift the ex parte order in this matter. Just to clarify, Ms. Shadowins, in your answer, I would have clarified for you, you had stated that Mr. Parks is employed by Umbarger, Zebo, and Bieberich, and he's semi-retired at this point. He hasn't worked from that office for, I guess, a number of years maybe. And in fact, he's only handling GAL cases at this point.
That may be, Your Honor. The only information I had since it was the information that was online. And so the information online indicated that he was still employed there and that it had been updated as recently as March of 2023. So I did check his bar member directory and he's not listed as belonging there. So I would suspect that that he's no longer working there. What I don't know, though, is whether when he was working there, whether or not these parties were still utilizing those services. Okay.
Well, what the court's going to do, I'll leave it. The court does believe it's appropriate. The court has had Mr. Parks appear at many cases as a guardian ad litem. So the court will appoint him as guardian ad litem in this matter. If again, Ms. Shadowins, if you come up with additional information or other information that might disqualify him, you can bring that to the attention of court, and then we will address the matter. But at this point, the court doesn't see any conflict based upon what's been presented. Ms. Capture, you can proceed on the issue concerning the ex parte order.
Thank you, Your Honor. Summer is about to begin pretty shortly. The plaintiff misunderstood the number 12. The reason for the ex parte was that there was a risk that either defendant or plaintiff may abscond with the child during the pendency of the proceedings. That has not occurred whatsoever. Defendant has multiple family connections outside of the state. It's in the benefit of the minor child to have those connections and to foster them to be able to travel during the pendency of the remaining trial, which potentially could go until the end of July. Because summer vacation is upcoming, vacations want to be planned. We don't have any in the works as of right now because it's ex parte. However, defendant would like the opportunity to be able to have the minor child around her family who live out of state. And I believe that plaintiff would also like to be able to travel with the minor child. I don't think either parent is going to abscond with the child at this point. So there's no risk and there's no need for the ex parte to remain. Furthermore, Your Honor, plaintiff did bring up the fact that there is an ongoing Child Protective Services investigation. That is, but again, that's why the GAL definitely needs to be appointed, and we're getting that resolved as quickly as possible.
Okay. Ms. Shadowlands, do you have any issue with, again, the lifting of the ex parte?
Your Honor, my client would simply like to continue what they've been doing since May of last year. Both parties have been limited in their ability to travel outside of the state of Michigan with the minor child. She just wants to continue that. And quite frankly, I do feel that this case has been somewhat volatile, which is really the reason why the court implemented the order in the first place. I suppose we could have the guardian ad litem look at the issue and determine whether or not he still feels that it would be appropriate. But right now, with the fact of the matter is that there's a safety plan in place that prohibits this anyway. So I'm not sure modifying it at this point makes a lot of sense.
Okay. Well, what the court's going to do, the court has reviewed the pleadings. Again, what the court will do is modify the ex parte, allow the children to be removed from the state for purposes of vacations, visits, etc., but they shall not be moved from the state of Michigan. As capture, you can include that in the order as a result of the issue concerning the guardian ad litem. You can submit it under 7-day notice of entry. Anything else, Ms. Capture?
Nothing further. Thank you, Your Honor.
Okay. Ms. Shadowlands?
No, Your Honor, thank you.
Okay. Court will end this matter at 9:36. Ms. Reed, on behalf of defendant, we got two matters: the defendant's motion to hold plaintiff in contempt and defendant's notice for entry of a QDRO. Ms. Thomas, I didn't see in the answer, maybe I missed it. Do you have any problem with the entry of the QDRO?
I do not.
Okay. The court will therefore enter that QDRO. In this matter, Ms. Thomas, you had stated in your answer that obviously the refinancing had been held up as a result of the delay in the entry of the judgment. The court will note, however, it was entered on February 9th, 2023. Where's your client at in the refinancing at this point?
The problem is that because her window of opportunity had closed, and then there had been a couple of payments that were made because they were all included in what she had the loan for. Now they won't loan her. They'll give her a partial loan, but it's not enough for everything she needs. She could do it, but they also are requiring that Mr. Morris also sign. And then apparently if she's diligent and pays her payments and whatever, then she could do it again. But at this point, she can't get enough money because of those late payments and that huge delay when things weren't being taken care of. She can't do what she thought during mediation when we settled this case that she could do without direct cooperation from him. And again, I know it's been a while since then, but she can't do what they won't do for her.
Well, I doubt whether Mr. Morris is going to want to co-sign on an obligation.
Right.
Is that pretty accurate, Ms. Reed?
Yes, Judge. And I guess part of my response too is, these parties renegotiated some terms of this judgment throughout the month of December, as Ms. Thomas notes in paragraphs 8 and 9 of her response. Why was this issue not brought to Mr. Morris's attention? Why was there no attempt to proactively deal with this delay that, was caused by part of, the plaintiff's actions? He has every reason to rely on this promise that was made throughout mediation. And so I think that could have helped resolve part of this problem. But now here we are, 4 months later, his credit has been damaged and there appears still no ability to fulfill the promises that she had made.
Your Honor, if I can respond just quickly, we did not know in December, which is why it wasn't brought to the forefront. We didn't know until once it was entered. I mean, once we had all signed it, we didn't know there was going to be that delay. So that's why we didn't discuss it before.
Okay, I don't care what the parties discussed before the judgment. I'm only concerned with what's happened since the judgment's been entered. So it doesn't appear, Ms. Thomas, that your client's able to refinance at this time. Is that accurate?
Correct.
Okay. What the court is going to do in this matter, the court is going to order that the house would be immediately listed for sale and sold. The proceeds will be used to pay the mortgage as well as the joint debts in this matter. And then again, distributed based upon what the judgment states in this matter. The court will note that the plaintiff has agreed that she would provide the title to the vehicle that's apparently in defendant's possession. Well, no, she'll provide that to him for him to sign off. Is that accurate, Ms. Reed?
Yes, the vehicle is in her possession, but his name is on that title, putting him at continuing liability.
Okay. Well, she's agreed to provide that title so he can sign off, et cetera, and transfer that to her. So the court will order that, as well as, again, order the sale. I'll reserve on anything else in this matter. So, Ms. Reed, you can prepare that order and submit it under 7-day notice of entry.
Your Honor, can I just ask a quick clarification question? Just so I know we're going to provide it. Is it something that if Ms. Morris drops it off here, that Mr. Morris could stop by here and sign it, or are we going to go through attorneys? I just want to make sure we all know what's going on.
Ms. Reed, do you have any problem with Mr. Morris going into Ms. Thomas's office and signing off?
Mr. Morris, do you have any problem with retrieving that from her office? No, he's muted, but it appears not, so that would be fine.
Okay. What we'll do is just have it dropped off to Ms. Thomas's office, and Mr. Morris can go in and sign the title at that particular point. Okay, Ms. Reed, you can prepare all of that and get it in the order, and we will conclude this matter at 9:43 a.m. You're free to go. Have a good day. Hearing on behalf of the front of the court, it's the front of the court's motion to correct the Uniform Child Support Order in this matter. Mr. Magnuson.
Yes, Your Honor. We are simply asking that the Uniform Support Order be corrected due to a clerical error and a technical problem. On the Uniform Support Order, the parties were switched, and that was clearly not the intention or the finding of the referee in this case. So we're simply asking that that order be modified to have it comport with the reality of the findings in this case. Okay, thank you. Ms. Parrish, I don't assume you have any objection to that?
No.
Okay, Mr. Weaver, what's your position? You're muted, sir. We can't hear you if you're talking.
Okay, so I actually got off the phone with Woodlands Associates. I would like this hearing to be adjourned, and I have a meeting tomorrow with my lawyer.
Okay.
And then, yeah.
Okay, with that, court will allow Mr. Weaver to again be represented. So I guess what we'll do is we'll adjourn the matter 1 week. So we'll hear the matter next week on the 8th at the same time. Ms. Parrish, you've been here. You don't need to appear back if you don't wish to do so.
Okay.
Okay. Okay, thank you.
Thank you.
Well, on behalf of the plaintiff, Mr. Todd, on behalf of the defendant, this matter is before the court on the plaintiff's motion to reinstate parenting time and to remove various conditions. Ms. Oatman.
Yes, Your Honor. We filed this motion asking that the court would revert the parties back to their original parenting time order, which would allow for a switch in the alternating weeks and no prohibition on my client's girlfriend to have her children present. There was a family CPS investigation that was at the beginning of this particular situation, and this court had ordered that the child in question not be allowed the party's minor child until further order of the court. That CPS investigation was unsubstantiated. The children have been attending counseling. My client is now asking that the reversion of the parenting time go back to what was previously in place. We're asking that the parties continue to use our family wizard. I did file a response to Attorney Todd's counterclaim, but I believe it arrived at the court this morning since I did not get the counterclaim until Thursday, and we submitted a response on Friday. So what we are asking is a reversion back to the original order without further hearings if possible. And I would like to ask that my response to the counterclaim be filed in the file if in fact this goes forward to any other hearings.
Okay, thank you. Mr. Todd?
Thank you, Your Honor. Your Honor, we do believe an evidentiary hearing is necessary. I believe the answer actually indicates that there has been good cause or change in circumstances in general to revisit custody and parenting time. My client has recordings verifying the child told her that the live-in girlfriend's child, Jacob, did in fact touch the party child, and that the plaintiff knew about this and simply put the child, Jacob, in timeout. The counselor was unilaterally picked by plaintiff, and the particular counselor lacks the credentials to determine if something did or did not happen. She has actually admitted this. During the party's counseling sessions, or during the child's counseling sessions, plaintiff's girlfriend is actually permitted to attend with this counselor who is not credentialed appropriately. So obviously the child wouldn't have disclosed anything yet because the child was previously chastised for saying anything. And the allegation is against plaintiff's girlfriend's son. So clearly the child isn't going to disclose anything in that environment because she was previously punished for that. The child has also stated that the alleged perpetrator, Jacob, still comes into a room, so the current order is not being followed. So we are respectfully requesting that the court modify and allow defendants to pick a counselor who is in fact properly credentialed. Additionally, the child advocate, at least in the YWCA, has indicated that this process could take a little while longer. We also filed a counterclaim, and again, it's our understanding that it was admitted that good cause or change in circumstances exist. Plaintiff was convicted of domestic violence after a CSC third was decreased down from a felony. That was pled March 24th. Additionally, it's come to light that plaintiff had admitted he himself is scared to sleep near the children for fear he will do something inappropriate. Plaintiff's being investigated by the Licensing Bureau in relation to his job. It's our understanding also that CPS is currently investigating the criminal sexual conduct charge because that was actually witnessed by the children. This also came out during one of the therapy sessions, not with the daughter, but with the son. So there's concern of continuing Millen also possibly, but again, because that therapist doesn't have the proper credentials, we can't necessarily see that. So we are respectfully requesting that the counselor be modified, that plaintiff's live-in girlfriend not be allowed to attend any of those sessions and not be allowed to attend pickup and drop-offs. And we do believe that it's appropriate to have an evidentiary hearing to, in essence, sort all of this out.
Okay. Thank you. Ms. Altman, any reply?
Absolutely. Yes. As far as the counselor being unilaterally picked, the parties had to pick someone who was accepted by their insurance. Mr. McMaster provided names. Ms. Burrell actually agreed to this counselor. This counselor has a master's of social work for the U of M. She's been employed as a therapist since 1993. She specializes in play therapy, although she is not certified as a play therapist. She's adequately educated, she's adequately experienced to deal with this type of a situation and these allegations. As far as the video recordings by Ms. Varel of the minor child, that would be highly inappropriate, and coaching is a very good possibility. I would ask that any investigations involving the minor children be done by the appropriate people who are actually trained to investigate these types of situations with minor children. It's my understanding that the Child Advocacy Center found that there was no allegations supported of sexual abuse of this child when they were originally met with the Child Advocacy Center, and that was not good enough for Ms. Burrell, and she proceeded to pursue this allegation without any supporting evidence. As far as the order not being followed, it is being followed. The minor child in question, Jacob, spends alternate weeks at his father's house, so he is never at Mr. McMaster's home when Kelsey is there. As far as a CPS investigation being started due to the allegations made against Mr. McMaster, that is not known to our knowledge. We don't have any information that is actually occurring. And as far as what the son may have disclosed at therapy, this is nothing that I have information of either. This is a brand new piece of information that has come to light this morning. As far as any of these allegations, I believe them to be false. I believe that the evidence would support that. And if this court feels that an evidentiary hearing is necessary to sort this out, I will have to concur, although it's costing my client an enormous amount of stress and time and money in order to to try and shut down these false allegations.
Okay, well, everybody makes that claim, so we'll have to wait and see when an evidentiary hearing happens. In this matter, Mr. Todd, you had stated that the counselor said that she was not qualified in this matter. Do you have something in writing of that or what?
Your Honor, I believe it does have an exhibit verifying that, and we're happy to choose another third-party neutral counselor. That's not a problem, but it's our understanding that that counselor is in fact not certified or qualified to make any determination through play therapy.
Okay, well, what the court's going to do is kind of condition that is let the attorneys determine whether the current counselor is in fact qualified. If not, then the court would order that the parties through their attorneys would pick another neutral third-party counselor in this case, and the counseling would continue. The court would reiterate in this matter that Jacob did not have any contact whatsoever, and the court at this point is going to continue the order of November 23rd, 2022 at this time, pending some additional counseling. I know it's been stated well that, again, counseling hasn't produced anything, and oftentimes it takes time for that to happen. And so the court is not going to simply make a preliminary, if you would, assessment in this matter. I'm going to deny the motion at this time with those other conditions and reiterations that I had. Mr. Todd, you can prepare that order and then see what we can do as it relates to the counselor, and then the court can revisit it after the counselor is able to have sufficient time to make a report in this matter. Okay. Thank you. The court will end this matter at 10:14 a.m. You're free to go. The court, the front of the court has filed a motion to correct the uniform child support order in this matter. Mr. Magnuson.
Thank you, Your Honor. This is a motion, as the court's indicated, to correct that order. In the body of the order, the parties were switched as far as who was the payee and payor. We are simply asking for a correction of that in order to have the order be consistent with the referee's finding and the situation as we have it now.
Okay, thank you. Ms. Walsh, you have any response?
No.
Okay. Mr. Ullman, any response?
No, I actually submitted a paper already, a motion to correct it already anyways.
Okay. Well, in view of that, the court does note that we've had a number of those hearings come up where the parties got switched. So the court will grant the motion to correct the uniform child support order. Mr. Magnuson, you can submit the appropriate order. Doing so, and the court will end this matter at 10:17 a.m. You're free to go. Court will note that this matter is before the court on the plaintiff's objection to the referee order in this matter. Ms. Kendra, what's your position in this matter?
Is that this man has not helped me support my kids. He does not financially. He is homeless. I've been at the gospel mission since July 19th, 2022. Due to a lot of domestic cases, he does not support his kids. Anytime I interact with him, with his kids, it's controlling, manipulative, abusive. He does not know any of my kids. March 7th, I had a court date for child support, which we have been staying at the gospel mission since July 19, 2023. He snatched up my son March 17th from school, only due to because they wanted to see who would be accountable for the child support. The gospel mission has been supporting me from diapers, wipes, housing. Okay,
ma'am, I don't need that information. I just need your information as it relates to your objection.
Yes, my objection is this man does not exist anything but filing falsified court papers. He does not help me with my kids.
Okay, well, tell me in this matter, because you're objecting to the referee order, where you have to establish the referee made a factual or legal error. What is the error that the referee made as to the order?
There was no investigation done to even prove anything of the decision. I know I missed some court dates. When I left Battle Creek, it was only 3 hours once a month, and that is not even tolerable with this man. We go through too many abusive situations dealing with him. He is homeless. He does not provide. He does not help with his kids.
Okay, well, again, it gets back to my question. That all may be true, but what is the error that the referee made as it relates either factually or legally in this matter?
We don't know the decision of why he has the kids. And on top of that, I want to go against custody because he has not did anything for custody for his kids other than I missed the hearings for that.
Okay, well, if you missed the hearing, then they probably decided it based upon the only evidence that was available at that time, and you missed the hearing, so they couldn't guess as to what you were going to say or present, and that's probably why they.
But I filed the motion again to prove everything of my trail paperwork and me only taking care of my kids. This man does not help me with my kids.
Okay, well, I thought you said he has custody of them.
Yes, they made the decision in September, which we didn't July 19th.
May I speak?
Yep, just a minute, sir. Go ahead, ma'am, finish up.
They made the decision in September. This man had no, like, it's been abandonment towards his kids before I even came here. If you look at the dates, he didn't show up to get his son. He snatched my son out of school. He does not participate in anything. He's the one keep filing things, but he does nothing behind the court paperwork. And then when I said in.
Okay. Mr. Etchison, what's your response?
Okay. I'm not for sure really how to go about it because I've been fighting for my kids for years and y'all have everything to state and document how much I've been fighting for them. I never missed a child support payment. And I was really hardly behind in child support when I was on child support. I got custody in September and I've been trying to get my kids from her ever since. Like my daughter, I've been going up to the women's shelter to try to get my kids. She will not hand over my daughter. And I've been trying to figure out ways to try to get my daughter. I had to literally pull my son from school and enroll him in the school here. And my son is happy. He plays sports. I'm his football coach. He is truly happy.
Okay. Well, there's a way in any of these cases, if you have issues as it relates to orders, you can file a motion to have the other party held in contempt and to enforce that order. So that's the way to do it. If you have a custody order, sir, you should be able to go with the police and pick up the child if the order states that you have custody of that particular child. So I don't know what your order is or isn't, because that's not an issue today's date, but you have a right to seek enforcement of that order.
Okay. I have the couple of times that I have brung an officer up to Kalamazoo, they was like, well, we cannot do nothing about it. And then I go through the front of the court. They tell me that I have to go in front of you to see if I can have an officer force her to hand over.
What you can do is file a motion seeking to have the police officers, what they call a pickup order, which would allow the police officers to go in wherever the child is and pick the child up. But you'll have to file a motion, provide notice to the other side so that she has a right to respond. That's all I can tell you at this point. Okay?
Okay.
Well, what the court's going to do in this matter is the matter is before the court on the plaintiff's objection to the order. The plaintiff has not identified any factual or legal error that the referee made at this particular point. There's a lot of complaints that she has, but not as it relates to the entry of the order. As a result, the court will deny the objection in the motion to set aside that order at this particular time. You can file the appropriate motions if you have anything further, but that will conclude this particular matter. So,
Attorney Jennifer Reed represents defendant respondent.
Court will note the appearance of Ms. Reed in this matter. This matter is before the court on the defendant's motion to terminate the personal protective order issued by Judge Josh Johnson back on February 26, 2023. What we're going to do is we'll take some testimony. Do you have any opening statement or just want to proceed to proofs?
I spoke with the petitioner this morning, Your Honor, and we've come to an agreement regarding the PPO.
Oh, okay. Okay, great. You should have told me that before.
Okay, we came to an agreement that the PPO will be terminated and in its place a mutual restraining order will be put in place in the divorce matter case number 23, where it will state that all contact between the parties must be peaceful and non-threatening, that if the respondent defendant is taking or prescribed any bipolar medications, he will continue to do so as prescribed, that the respondent will be able to pick and drop off the minor children from the marital home for his parenting time. He will be able to attend any and all and participate in school activities or school functions. And then he will not appear at the marital home without plaintiff's consent in writing. And then we will circulate that order for everyone to sign.
Okay. Ms. Heckman, is that your understanding of the agreement?
Yes, it is.
Okay, you understand you don't have to come to an agreement, but if you do, you're doing so freely and voluntarily. Is that correct?
Yes.
Has anyone threatened you, coerced you, used any undue influence, pressure, or promises to get you to come to an agreement in this matter?
No, they haven't.
Okay. I'll let you know as well, Ms. Heckman, that at any point, should you desire or need to in the future, you can always petition for an additional PPO. So the fact that this one's being terminated doesn't mean that you can't apply for another one in a day or a week or a month or a year from now. You understand that?
Yes, sir.
Okay, thank you. Well, with that, the court will again grant the petition based upon the agreement of the parties to terminate the personal protective order. And that will conclude this matter at 11:06 a.m. And Ms. Heckman, you should be getting another order from Ms. Reed that would, again, have that injunction in place in the underlying divorce action, okay?
Okay.
Okay, so look at that when you get it, and if that's correct, then you can sign it, send it back to Ms. Reed, she'll get it to the court, and then we'll get it entered. Okay, thank you all, and you're free to go. We'll get this order entered once we get off the streaming with you, and that will close out the PPO.
Have appeared.
Thank you, Your Honor.
Court will know it is now 1:32 p.m. The matter was set for 1:15 p.m. As a result of failure to appear, the court will dismiss the action. So we'll send out an order of dismissal. I don't want to even send a notice of intent. We'll just dismiss it.
Very good, then. We will do that.
They can refile if they want to.
Okay, so we are going to move on here. 2023 at 1:34 p.m. Attorney Jonathan Vanderhorst represents plaintiff.
We will go to the plaintiff first, and Mr. Vanderhorst, let us know what's happening in the case.
So far, Your Honor, we had a initial motion hearing on or about January 23rd, where you granted the parties joint physical, joint legal, 223 schedule. We had the scheduling conference. Mediation was scheduled for April 12, but was canceled by the mediator, John Brundage, due to no contact with the defendant. So right now, our position is either, order defendant to attend mediation with John Brundage again, or potentially set the case for trial.
Okay. Ms. Gray, why have you not been in contact with Mr. Brundage?
So I recently moved, and I got a new address. So I called Mr. Bundy after learning from the plaintiff that I missed the mediation. I do recall hearing about the mediation when we first talked about the case, but there was never a date set. When I did call the mediator, he told me that there was a notice sent out, but it was sent to my old address, so I never got it. And when I called him, I asked him if we could reschedule. He told me to ask today.
Okay.
But I intentionally, and I didn't get any phone calls. And I learned, like I said, from the plaintiff that I missed the mediation.
Okay.
And
Okay. Well, the court will again allow you to go ahead and proceed with mediation. So, Mr. Vanderhorst, if you could contact Mr. Brundage's office and try to get in touch with him, see if we can't get in as soon as you can. We'll attempt to do that.
Okay.
Mr. Vanderhorst, do you have Ms. Gray's new address?
I do not, Your Honor.
Okay. Ma'am, could you give us your new address?
is there a way that I could do it like without the plaintiff knowing my new address? I did not want him to know my new address.
You can send that address. You can contact Mr. Vanderhorst and give him your address then after this hearing, so that he can be able to get in contact with you. Give him a phone number as well, because he may just call you and tell you when that mediation is scheduled.
Okay, thank you.
Okay?
Okay.
Anything else, Mr. Vanderhorst?
No, nothing further, Your Honor. Thank you.
Okay. Let us know, Mr. Vanderhorst, when the mediation is scheduled, because we'll set up a new settlement conference after that date.
I'll do that.
Okay.
Okay.
Well, that's all we can do today. The court will end
First,
this matter
2023 at 1:38 p.m. Attorney Anya Henderson for plaintiff and Attorney Christopher Podol for defendant.
Okay. Good afternoon to all of you.
Hi, Judge.
Ms. Henderson, we've been informed that you did have resolution in the case and you wanted to proceed with a pro-con. Is that correct?
That is correct, Your Honor. Yes.
Mr. Podol, is that your understanding?
It is. I do have a brief thing I want to run by Anya real quick, just to make sure she's on board.
Okay. Go ahead.
Anya, so my client has indicated on the one retirement account we were talking about that he's still having trouble getting exactly what you're asking for the FERS. And so in light of that conversation this morning, I told him, that I would be of as much help as I can. If he wants to give me the contact information, I can try reaching out to them. But I mean, he is adamant that the amount balance that was in there should not exceed 10,000. And so what he's basically saying is he's willing to stay at the 40 as long as she's willing to let that go. If she wants to say, well, I want half the retirement account, he's okay with that too. But then he wants to raise the amount that he receives on the home by 5,000, recognizing that he knows, like, he may not be able to prove it at this moment in time, but he knows that there's only about 10 grand in there. So I don't know how you want to proceed with that.
Well, I think we still have a settlement, Chris, in terms of what's happening in the finality of the case. We are not going to be final until mid-June. So I think by that time, for sure, we would be able to get a statement from your client's account.
Yeah.
And then proceed according to what you told me. She would receive 1/2 of that retirement account. But again, we would look at the statement and see where we stand. I don't think that changes the fact that we essentially are settled. I have the judgment prepared with the exception of that last retirement account information.
And I just want to make sure that he understands, because I think what he's getting at is if she's to receive 1/2 of that account, then he wants to increase what he would receive on the home by 5,000.
Well, like I said, I think we can work all of those details out once we see the statement. I don't think that changes the fact that we essentially have a settlement. Does that make sense?
Yep, I'm fine with that.
Okay. So Ms. Henderson, you want to proceed with your client and we'll get her sworn in?
Yes, Your Honor. Did you consult our law firm in December of 2022 regarding filing for a divorce?
I did.
And have you in fact signed a complaint for divorce on or about December 9 of 2022?
I did.
Did you review the complaint for divorce to make sure all allegations therein were correct?
I did.
And are those allegations still true today?
True.
Have you been a resident of Calhoun County for 10 days and the state of Michigan for 180 days prior to filing the complaint?
I did.
Do you have any minor children born into the marriage?
I have.
How many?
1.
Have you reached a fair settlement regarding custody, parenting time, and child support?
I did.
Are you currently pregnant?
No.
In your complaint, you allege that there has been a breakdown of the marital relationship to the extent that the objects of matrimony have been destroyed, and there remains no reasonable likelihood that the marriage could be preserved. Could you please briefly state to the court what led to the breakdown of your marriage?
Just there happened some events that destroyed the marriage.
And in the event that the judge were not to grant the divorce when the statutory period is up, is there any reasonable likelihood that you and Mr. Ranger would reconcile?
No.
Is it true that you have reached a fair property settlement and we're just waiting for some information to finalize the judgment?
Okay, just can you repeat this question, please?
Is it true that you have reached a fair property settlement and we're just waiting on some information to finalize the judgment?
It's true.
Thank you. May it please the court?
Court is satisfied that the testimony does establish a statutory basis. There has been a showing there's been a breakdown of the marital relationship. The court will preserve the proofs in this matter pending receipt of the approved judgment. You're not divorced until we sign that paperwork, which, so when that comes in, we do have a waiting period, so we'll have a little bit more time. And then once that waiting period is up, then we'll be able to sign it and get the matter completed. So best of luck to both of you. I hope everything works out for you. And the court will end this proceeding at 1:44 p.m.
For plaintiff and attorney Mark Bailey for defendant.
Okay. I'll start with the plaintiff, Mr. Padol. Tell me what's happening in the case.
Yes, good afternoon, Your Honor. We mediated this case last week. We did reach an agreement regarding property. I think the parties are on board in terms of custody, but we were unable to reach an agreement at that time regarding parenting time and where the minor child will begin school. The child is slated for kindergarten this coming fall. And so that is a raised issue. In addition, and again, I was going to reach out to Brother Counsel about this prior, but the information just became available to me briefly before the hearing, which is that my client has been maintaining for quite some time, and even through mediation, that the defendant was not truthful about his assets or the manner in which he received them. And there are a few financial issues that my client sought to verify after mediation, and she is now still in the camp that there are some accounts that were not brought forward in mediation in good light. They were misleading as to the balances or the manner in which the assets were received. And so she is, there is a signed mediation agreement on property, but my client is maintaining that she was induced into signing that agreement on the basis that certain accounts weren't what they said they were, and or whether they existed or didn't exist. So that is an issue that we have currently, and I don't know how Brother Counsel would like to proceed with that. If he wants to, I imagine he will want to seek to enforce the mediation agreement as agreed on between the parties. There are a few accounts that I would like to address. I'm not necessarily seeking to set aside the entire agreement, rather address some of these, a couple of these issues that came up.
Well, look at it this way. What happens if you have concrete information that there was misrepresentation or simply could be an error, then you have a right to proceed and remediate if you want to do that, or otherwise file a motion and bring the matter in, and we can set aside mediation or portions of the mediation if that's the case. So
if I may, Judge, this is the first time I'm hearing this. It's literally right now. I have no idea precisely what accounts he may be referring to. One of the conditions in the mediation agreement is that my client would provide a bank statement that was in existence at or near the time that the complaint for divorce was filed, which he today came to see me. Obviously, you can see that this is Mr. Pick, and he brought those documents to me, which I was going to be forwarding. So what other documents they may be referencing, I have no idea, but absent some concrete proof he's correct, we will be attempting to enforce the mediation agreement that we had with John Brundage last week, which divided the assets and the liabilities that the parties have accumulated during this very short marriage.
Okay, well, why don't you get the documents that you have exchanged and see what impact that has upon the agreement, if any, and then I guess we'll have to argue about that at some point. So
as to the remaining issue, we attempted to mediate portions of the parenting time agreement, and we were unsuccessful doing that. The primary issue, as Mr. Padol has pointed out, is the parties share joint legal and joint physical custody. The parenting time was ordered by this court following a hearing in February of 2023. And the parties have been exercising week on and week off parenting time with their 4-year-old. My client, who lives about 40 miles away, was unwilling to modify the parenting time as was proposed, and we wanted the schedule that is in place to remain in place and be incorporated in the judgment of divorce. Furthermore, the other issue will be school district. They both live in different school districts. And as Ms. Fick has moved to the Battle Creek area, my client lives in the Charlotte area. So I don't know with the school, the child's 4, with the school issue in the fall, if that's something the court would want to address now anyway.
Well, we can address it. We're going to have to address it before fall anyway, so.
Yeah, so those are
time for an evidentiary hearing on parenting time in school district and see if you can work out the remaining issue as it relates to these accounts or account. And if you're able to work that out, then we'll just proceed on those 2 issues with the evidentiary hearing. So we'll contact your offices maybe today, later today or tomorrow, and set up a time when you'll be available.
Sounds good. Thanks, Judge.
Okay. Thank you.
Judge.
Okay. Have a good day, and you're free to go.
Bye now.
Thank you.